Hey, folks, welcome to today's episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very much. And here, going to have some fun in today's show because we're going to be reading from a Second Amendment favorable federal court decision out of California, no less. And it's a court decision that finds unconstitutional California's ban on standard capacity magazines. Many of us live under these kinds of fascist gun control laws. We have them here in Colorado. Theoretically, 15-round magazine limit here in Colorado. It's kind of silly. High capacity mags are in every gun store I walk into, or should I say standard capacity mags, which is really what they are. What the gun control fascists are trying to impose are artificially low capacity mags, but only on law-abiding people, of course, because criminals don't obey gun laws, do they? They're criminals. So California has long had a standard capacity magazine ban, and it's been litigated by many of our friends in the Second Amendment community, notably by the law firm of which attorney Costas Moros is a member, the California firm of Michael and Associates. I don't know if they were participating in this particular litigation over California's magazine capacity ban, but I suspect they were. I did see Chuck Michael, of the senior partner of Michael and Associates, comment on this decision on Twitter, on X, saying it put a tear in his eye of happiness, of course. And I'm right there with him. So today we're going to read through this decision by Judge Benitez. It's 71 pages long. I'm not sure we're going to read the whole thing. I have about an hour to share with all of you today, but it's such a refreshing recognition of the Second Amendment protections that we're all entitled to as law-abiding, mentally sound American citizens. And of course, it's not really a self-defense case per se. This is law of self-defense. I do, as you know, occasionally cover Second Amendment issues because, let's face it, without our ability to own guns and the things we need to make the guns work, like ammo, like magazines, self-defense by law-abiding citizens becomes much more complicated, right? We're not in prisons lifting weights all day. We're not purchasing guns contrary to the law. We're not, most of us, spending years of our lives developing some kind of high level of martial arts expertise. We don't operate in gangs so we can outnumber our victims. We don't attack by ambush. So it's much easier for the bad guys who get to choose the time, place, and manner of attack. Guns are what equalizes us against the predators in society. So it's pretty important. In addition, of course, to the other reasons for owning guns, notably to resist tyranny, for personal enjoyment, for competition, for hunting. But certainly a core value of the right to keep and bear arms is self-defense, being able to defend yourself, your family, your property against criminal predation. So that's what we're going to be talking about today. Let's see, with that out of the way, let me go ahead and start up the launch of today's show. Here we go. Welcome, everybody. Welcome. I'm so pleased that you are all here. And because of the public interest in this kind of law, Second Amendment law, today's show will be an open access show. So we'll do the whole thing on, of course, to our members, lawofselfdefense.com, as well as on the Law of Self-Defense YouTube channel, Rumble channel, and Twitter channel. In fact, on Twitter, let me go ahead and pin this up right now before I forget entirely. Make sure YouTube is streaming. Yes, that's streaming. And I wasn't quite sure about Rumble because, it looks like it's working too. That's why I was a couple minutes late today, folks. I had forgotten to set up the Rumble properly, but it looks like we are all here. So let's get ready to dive into all this. Before I do, I will mention, of course, that we have coming up in let's see, how long is it now? I think it's less than 2 weeks. Yes, about a week and a half. So a week from this coming Saturday, we have one of our rare, we only do them twice a year, folks, rare Law of Self-Defense advanced classes. This is our full day class. It's being taught on Saturday, October 7th. We spend the entire day together. It's our most comprehensive instruction on use of force law, defense of yourself, your family, your property. We have a couple different bundles that you can choose from. This is the webpage here. It is at lawofselfdefense.com/advanced. I think I have a little scrolling banner there. lawofselfdefense.com/advanced. And these red bullet points that you see on the screen, these are the more than 100 very specific issues that we address over the course of the day. And then we effectively have unlimited Q&A as well. So if you want to be prepared to defend yourself, your family, your property decisively, knowing you're well inside the legal limits because you know where the actual legal limits are, this is the class you'll want to be at Saturday, October 7th, 2023. And right now you can save up to 50% on the normal price of those tickets. And by the way, if you can't make the specific date, don't worry about it. We make the replay of that October 7th course available to all the registered students. So if you can't be there live on Saturday, you'll get a link to the recorded playback of the day. Even if you were there, you'll get that recorded playback so you can listen to portions again. You can listen to the class over a period of a couple of weeks if you want, instead of having to do it as one 7-hour chunk of time. So I would encourage you to take advantage of this. We only do these twice a year. The next one is not until the spring of 2024. Can you afford to wait another 6 months? But do you know you're not going to be attacked and have to defend yourself in the next 6 months? We're not exactly becoming a safer society, folks. So I urge you to take advantage of this. lawofselfdefense.com/advanced. And with that out of the way, let's flip over to the decision. All right. By the way, written beautifully written decision. A real pleasure to read. For those of you who are Law of Self-Defense members, I'll put the link to this decision in the blog post version of today's show when it goes up, the playback version of today's live stream when it goes up later today. Roger Benitez, United States District Judge. The decision was handed down on September 22nd, 2023. So just last week. And it's well worth reading the entire thing. I'm not sure how much we'll get through it today in today's live stream. As I say, I have about an hour to share with all of you today. So let's back up to the top. It's always so nice to have a well-written decision. I mean, a lot of these, the Ninth Circuit decisions on Second Amendment issues, when they're negative to the Second Amendment, they read like word salad, like someone was on mushrooms when they wrote it. So a coherent, legally sound, constitutionally sound decision, which invariably has to come out in favor of the Second Amendment. That's why it's coherent. It's such a joy to read. All right, so let's hear what Judge Benitez has to say. We begin at the end. California's ban and mandatory dispossession of firearm magazines holding more than 10 rounds was preliminarily enjoined in 2017. So this began 6 years ago, folks. That decision, the effort to do away with this travesty of the Second Amendment, this standard capacity magazine ban, that decision was affirmed on appeal. In 2019, summary judgment was granted in favor of the plaintiffs, and the magazine ban, was judged to be unconstitutional. Initially, that decision was also affirmed on appeal. However, the decision was reheard and reversed by the Court of Appeals en banc. So en banc, folks, normally you have, the way this works is you have 3 tiers of federal courts, kind of 3.5, as I'll explain. So you have the trial courts. Judge Benitez is a U.S. District Court, trial court, federal trial court judge. You appeal that up to the Federal Court of Appeals. That's a 3-judge panel. In theory, randomly selected 3 judges from the pool of appellate court judges in the Ninth Circuit. And they hand down a decision, but that decision can, in theory, the decision, if you wanted to appeal it, would be appealed to the U.S. Supreme Court. So those are the 3 tiers: federal trial court, federal appellate courts, U.S. Supreme Court. But there is a path by which a 3-panel appellate court decision can be heard by a larger pool of the mid-level appellate court judges. It's typically not all of them because there's a lot of them, but there might be a pool of 9, for example, selected to basically rehear what the mid-level appellate court heard and ruled. And the Ninth Circuit, of course, is the most reversed appellate court in the federal system by a large margin. And they're terrible, as you might imagine, on Second Amendment issues because, they include California and a bunch of other liberal states. So often, traditionally, when you had a mid-level appellate court in the Ninth Circuit that returned a Second Amendment favorable decision with a 3-judge panel, it would be sent to be heard en banc. And en banc, the 3-judge panel's decision would be reversed without ever having to go to the U.S. Supreme Court. Very common. That's what happened here. So the magazine ban was found to be unconstitutional. California's magazine ban. This was affirmed on appeal. A Ninth Circuit mid-level appellate court affirmed that the magazine ban was unconstitutional, but then they went en banc, and the en banc panel reversed that decision. So put the magazine ban back into effect. But then in 2022, the United States Supreme Court granted certiorari, vacated the en banc decision, and remanded the case back to the trial court for reconsideration. The reason for that, of course, was Bruin. The U.S. Supreme Court decision of New York State Rifle and Pistol Association v. Bruin, heard in 2022, it set a new standard for hearing Second Amendment cases. Basically, that the state arguing for the restriction, the infringement of the Second Amendment right, has to show some historical tradition of the restriction being found in American history and tradition. And if they can't do that, the restriction is simply unconstitutional. So in light of the Bruin standard, the U.S. Supreme Court said, all right, this whole magazine capacity ban thing, this has to be reheard in light of Bruin. So it went back to Judge Benitez to hear the original arguments all over again in light of Bruin. All right, introduction. There's a long tradition of widespread lawful gun ownership by private individuals in this country, according to the U.S. Supreme Court. Americans have an individual right to keep and bear arms. The Second Amendment to the United States Constitution guarantees the individual right to possess and carry weapons in confrontation. Now, folks, when I read these cases, I don't normally refer to the footnotes because they're often incidental. But see all the footnotes here? Every one of these sentences has a footnote to other jurisprudence, including McDonald, one of the key Second Amendment decisions of our generation, as well as to Bruin. And these are U.S. Supreme Court decisions. So the more that Judge Benitez cites to explicit U.S. Supreme Court decisions and language in this decision, it makes it much harder for an appeal of this decision to be reversed on a rational basis. Now, of course, as I said, the Ninth Circuit often resorts to irrational word salad, so they might do that here too. And we might have to find ourselves again at the U.S. Supreme Court on this particular issue. But if they do that, they're doing it irrationally, without legal basis. Continuing, this guarantee is fully binding on the states and limits their ability to devise solutions to social problems. And the guarantee protects the possession of weapons that are in common use or arms that are typically possessed by law-abiding citizens for lawful purposes. Now citing to Caetano versus Massachusetts, which found that the Second Amendment applies not just to firearms, but to weapons generally. It's These are the decisions this court, Judge Benitez's trial court, is bound to apply. It's our duty as judges to interpret the Constitution based on the text and original understanding of the relevant provision, not on public policy considerations, or worse, fear of public opprobrium or criticism from the political branches. In other words, just do the right thing. That's your job. This case is about a California state law that makes it a crime to keep and bear common firearm magazines typically possessed for lawful purposes based on the text, history, and tradition of the Second Amendment. This law is clearly unconstitutional. There it is. And the remaining 70-some pages of this decision are simply affirm that conclusion in a very sound and robust way. Continuing, the detachable firearm magazine solved a problem with historic firearms, running out of ammunition and having to slowly reload a gun. When more ammunition is needed in case of confrontation, a larger the magazine is required. Many gun owners want to have ready more than 10 rounds in their guns. As a result, in the realm of firearms, magazines that hold more than 10 rounds are possibly the most commonly owned thing in America. These larger magazines number over 100 million. For handguns, the most popular sizes range up to 17 rounds. The most popular size for rifles is 30 rounds. That would, of course, be for the AR platform. Yet, regardless of the overwhelming popularity of larger magazines, California continues to prohibit any magazine capable of holding more than 10 rounds. There is no American tradition of limiting ammunition capacity, and the 10-round limit has no historical pedigree, and it is arbitrary and capricious. It is extreme. Our federal government and most states impose no limits. And in the states where limits are imposed, there is no consensus. Delaware landed on a 17-round magazine limit. Illinois and Vermont picked limits of 15 rounds for handguns and 10 rounds for rifles. Colorado went with a 15-round limit for handguns and rifles and a 28-inch tube limit for shotguns. New York tried its luck at a 7-round limit. That did not work out. It was reversed. New Jersey started with a 15-round limit and then reduced the limit to 10 rounds. The fact that there are so many different numerical limits demonstrates the arbitrary nature of magazine capacity limits. In a stealth return to the interest balancing test rejected by Heller and Bruin, the state, California, ostensibly justifies its magazine limits by deeming the smaller magazines well suited for its citizens. So, folks, interest balancing is when an argument can be made that, hey, yes, there's pluses and minuses to both sides, and the state gets to make a policy call. So long as it has any rational basis, makes a policy call. So, in effect, whatever excuse the state can verbalize is invariably found to be sufficient for the infringement of the right under an interest balancing test. So you know what the outcome of a decision is going to be when one of these gun control laws is litigated, because if the court applies an interest balancing test, the infringement is allowed. When the court applies Bruin, the outcome is much different. Because Heller, a U.S. Supreme Court Second Amendment decision, and Bruin, the same from last year, said that interest balancing tests cannot be applied to the Second Amendment because it is an enumerated fundamental constitutional right. Now, the courts don't like this. The courts that want gun control, certainly the state doesn't like it, because the state always won under interest balancing. That's why they have this stealth return to the interest balancing test rejected by Heller and Bruin. Continuing now, suitability, in turn, is based on concocted statistics about what a hypothetical average person needs to defend against an attacker or attackers in an average self-defense situation. Based on this hypothetical, statistically average case scenario, California permits its citizens to have a gun, but the state decides the number of rounds in the gun that it finds suitable. And then this footnote is interesting. And be grateful that you're even allowed 10 rounds. In footnote 24, quote, California currently allows more than 2.2 rounds in a magazine and does not prohibit carrying multiple magazines, but don't be fooled. Under the legislative majority's version 2.2 of the Second Amendment, there's no reason a state couldn't limit its citizens to carrying a generous, sarcastically, 3 rounds total for self-defense. Continuing with that same footnote, as this court explained in its prior decision, artificial limits will eventually lead to disarmament. It is an insidious plan to disarm the populace, and it depends on, for its success, a subjective standard of necessary lethality. It does not take the imagination of Jules Verne to predict that if all magazines over 10 rounds are somehow eliminated from California, the next mass shooting will be accomplished with guns holding only 10 rounds. To reduce gun violence, the state will close the newly christened 10-round loophole and use it as a justification to outlaw magazines holding more than 7 rounds. The legislature will determine that no more than 7 rounds are necessary. Then the next mass shooting will be accomplished with guns holding 7 rounds. To reduce the new gun violence, the state will close the 7-round loophole and outlaw magazines holding more than 5 rounds, determining that no more than 5 rounds are suitable. And so it goes until the only lawful firearm, law-abiding, responsible citizens will be permitted to possess is a single-shot handgun. Or perhaps one gun, but no ammunition. Or ammunition issued only to persons deemed by the state to be trustworthy. All right, continuing with the decision proper. In so doing, the state denies a citizen the federal constitutional right to use common weapons of their own choosing for self-defense. There have been, and there will be, times when more than 10 rounds are needed to stop attackers. And again, I have to read these footnotes. They're fantastic. So this is footnote 25. Some have wishfully believed there is no evidence that anyone ever has been unable to defend his or her home and family due to the lack of a large capacity magazine or that more than 10 rounds is ever needed. But there is actually the evidence to support this. In fact, the state's own expert reports otherwise. Quote, as 2 masked and armed men broke in, Susan Gonzalez was shot in the chest. She made it back to her bedroom and found her husband's .22 caliber pistol. Wasting the first rounds on warning shots, she then emptied the single pistol at one attacker. Unfortunately, now out of ammunition, she was shot again by the other armed attacker. She was not able to reload or use the second gun. Both she and her husband were shot twice. 42 bullets in all were fired. The gunman fled from the house but returned. He put his gun to Susan Gonzalez's head and demanded the keys to the couple's truck. Another case, when 3 armed intruders carrying what looked like semi-automatic pistols broke into the home of a single woman at 3:44 a.m., she dialed 911. There was no answer. Feng Zhu Chen, dressed in pajamas, held the phone in one hand and took up her pistol in the other and began shooting. She fired numerous shots. She had no place to carry an extra magazine and no way to reload because her left hand held the phone, with which she was still trying to call 911. After the shooting was over and 2 of the armed suspects got away and 1 lay dead, she did get through to the police. The home security camera video is dramatic. Another case, a mother, Melinda Herman, and her 9-year-old twins were at home when an intruder broke in. She and her twins retreated to an upstairs crawl space and hid. Fortunately, she had a .38 caliber revolver. She would need it. The intruder worked his way upstairs, broke through a locked bedroom door and a locked bathroom door, and opened the crawl space door. The family was cornered with no place to run. He stood staring at her mother and her 2 children. The mother shot 6 times, hitting the intruder 5 times when she ran out of ammunition. Though injured, the intruder was not incapacitated. Fortunately, he decided to flee. More examples have been reported since those words were written, when 4 suspects in a stolen car with stolen guns and ammunition used stolen house keys to enter the victim's home in Tallahassee, Florida at 3:37 a.m. The victim fired 25 rounds before the suspects retreated out of the home. Just great stuff. All right, back to the decision proper. Let's see, where was I? There have been and there will be times when many more than 10 rounds are needed to stop attackers, yet under the statute, the state says, too bad. It says, if you think you need more than 10 chances to defend yourself against criminal attackers, you must carry more magazines or carry more bullets to hand reload and fumble into your small magazine while the attackers take advantage of your pause. On the other hand, you can become a criminal too. So the previously law-abiding California citizen who buys and keeps at her bedside a nationally popular Glock 17 with its standard 17-round magazine becomes the criminal, because the state dictates that a gun with a 17-round magazine is not well suited to home defense. Now footnote 26 here. Criminals sometimes do not abide by gun regulations and pass around gang guns with magazines larger than 10 rounds. No kidding. No kidding. All right, continuing. Numbers vary, but some estimate that 81 million Americans own between 415 and 456 million firearms. Further, millions of Americans across the country own large capacity magazines, of course, what we would call standard capacity magazines. One estimate shows that civilians possessed about 115 million large capacity magazines out of a total of 230 million magazines in circulation. Put another way, half of all magazines in America hold more than 10 rounds. A more recent large-scale survey estimates that Americans today own 542 million rifle and handgun magazines that hold more than 10 rounds. Home defense and target shooting are the two most common reasons for owning these larger magazines. Moreover, the survey reports 48% of gun owners have owned a handgun or rifle magazine that holds more than 10 rounds. But California bans these typically possessed firearms kept and used for self-defense. Why are larger magazines chosen for self-defense? Crime happens a lot. One recent estimate holds that guns are needed defensively approximately 1,670,000 times a year. I wonder if this is from... Okay, never mind. Another report originally commissioned and long cited by the Centers for Disease Control and Prevention estimates that there are between 500,000 and 3 million defensive gun uses in the United States every year. Woe to the victim who runs out of ammunition before armed attackers do. The police will mark the ground with chalk, count the number of shell casings, and file the reports. All of this, Judge Benitez writes, was decided earlier. What remains to be done? California's magazine capacity ban must be assessed in light of Bruin. Now, on remand, reconsideration by the trial court, the state has to justify this ban under Bruin, which makes clear that to justify its regulation, the government may not simply posit that the regulation promotes an important interest. That's the interest balancing. After all, the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. So the state, California, must demonstrate that its extreme magazine capacity ban is consistent with this nation's historical tradition of firearms regulation. As explained below, there is no national tradition of prohibiting or regulating firearms based on firing capacity or ammunition capacity. All right, here we get through some constitutional standards. I've previously covered Bruin, so I'm going to skip over much of this just in the interest of time. Heller describes to keep and bear arms. Let's see, blah, blah, blah. And again, I've covered Heller too, and McDonald too. So not to recover all that ground. The judge has to do it here, of course. Let's see. Was this something important? Okay, I'm just going to continue here. Magazines are protected arms. Likes to argue is, oh, no, you can have a gun. The Second Amendment protects your right to have a gun. We're not going to take your guns away. You just can't have any ammunition for the gun. You just can't have any magazines for the gun, or at least only the magazines we tell you you can have. This is akin to the state saying, oh, no, you have a First Amendment. You can write your political views as much as you want. You can't have ink and you can't have paper. But of course you have the right to free speech. I mean, it's insane. But of course, gun control is a fundamentally irrational proposition from the start. So magazines are protected arms. That's the conclusion here of the judge. The state argues that larger capacity magazines are not arms protected by the Second Amendment. First, the state argues that magazines are not essential to the use of firearms and consequently would have been thought of as accessories. But magazines are integral components to vast categories of guns. Most pistols are manufactured with magazines holding 10 to 17 rounds, and many popular rifles are manufactured with magazines holding 20 or 30 rounds. While the Second Amendment does not explicitly mention ammunition or magazines supplying ammunition, without bullets, the right to bear arms would be meaningless. This is because the right to keep firearms for protection implies a corresponding right to obtain the bullets necessary to use them. The possession of arms also implied the possession of ammunition. By extension, arms includes the magazine component necessary to supply the bullet into the chamber of the gun. Our case law supports the conclusion that there must also be some corollary, albeit not unfettered, right to possess the magazines necessary to render those firearms operable. It is hard to imagine something more closely correlated to the right to use a firearm in self-defense than the ability to effectively load ammunition into the firearm. Put more broadly, the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. Consequently, whether thought of as a firearm able to fire a certain number of rounds because of its inserted magazine, or as a separate ammunition feeding component, magazines are usable arms within the meaning of the Second Amendment. As the Third Circuit Court of Appeals found, we therefore must first determine whether the regulated item is an arm under the Second Amendment. The law challenged here regulates magazines, and so the question is whether a magazine is an arm under the Second Amendment. The answer is yes. Proffering two subsidiary arguments, the state says, 1, a magazine of some size may be necessary, but a magazine larger than 10 rounds is not necessary to operate a firearm, and thus a larger magazine is not a protected arm. And 2, statistically, people rarely fire more than 10 rounds in self-defense, so it can be said that a magazine larger than 10 rounds is rarely used for self-defense. And if a larger magazine is not commonly used for self-defense, then it is not a protected arm under the Second Amendment. For the first argument, the state claims that if a standard 17-round magazine is detached from a standard Glock 17 pistol, the 17-round magazine is no longer a weapon by itself. And because the Glock 17 pistol could still function with a substitute 10-round magazine, then the 17-round standard Glock magazine does not come within the definition of arms that the Second Amendment protects. In contrast, according to the state, a magazine holding 10 or less may qualify as a protected arm, but a magazine able to hold 11 or more is not a protected arm. What the state seems to be really saying is that a magazine may be a protected arm, but only the state has the right to pick the number of rounds a citizen may have in his gun. This court disagrees. The Supreme Court has not described protected arms in subdivided categories. When Heller found handguns were protected, it did not distinguish between semi-automatic pistols and revolvers. Heller did not classify protected handguns according to the number of rounds one could hold or the caliber of the ammunition that could be fired. It did not suggest that typically possessed arms could be subcategorized and subjected to judicial ad hoc constitutional determinations. Whether thought of holistically as a handgun, irrespective of magazine size, as Heller does, or as an entirely separate attachment, both firearms and their magazines of all typical sizes are arms covered by the text of the Second Amendment. This is not even a close call. As this court has said before, neither magazines, nor rounds of ammunition, nor triggers, nor barrels are specifically mentioned in the Second Amendment, but without a right to keep and bear triggers or barrels or ammunition and the magazines that hold ammunition, the Second Amendment right would be meaningless. Using reasoning that is still persuasive, the Ninth Circuit agreed, explaining, put simply, a regulation cannot permissibly ban a protected firearms components critical to its operation. More recently, lawyer for California's governor in a related fee-shifting case agreed that while pointing out that the large capacity magazine ban appears in the penal code's title on firearms, and a restriction on the ammunition that may be used in firearm is a restriction on firearms, leaving no doubt even the vacated Ninth Circuit's en banc decision that reinstated the magazine ban assumed that the law implicates the Second Amendment. Relatedly, the state argues that it is only restricting a firearm component or an accessory. Let's take a look at this footnote 75. Instead of isolating the magazine from the gun, Judge Benitez writes, the better understanding is to consider the magazine as part of the gun. There is a federal law analog leading to the conclusion that a magazine is correctly recorded as a component part of the gun. The Arms Control Export Act criminalizes the unlicensed export of firearms and their components. Firearm magazines come within that act because a magazine is useful only when used in conjunction with that end item. Its sole purpose is to load cartridges into the breech so they can be fired. In this view, the magazine is a necessary component of a gun, which in turn would obviously fall under the text of the Second Amendment protection of arms. Large capacity magazines are not weapons in themselves, says the state, nor are they necessary to operate any firearm for self-defense. California residents who purchased new pistols in the last decade are probably surprised to hear that magazines are not necessary to operate a pistol. After all, another state law, known as the Unsafe Handgun Act, requires new semi-automatic pistols to have an integrated magazine disconnect mechanism in order to be sold to the public. A magazine disconnect mechanism prevents a pistol from firing at all, even if one round is left loaded in the chamber if the magazine is not inserted into the pistol. The state-mandated magazine disconnect mechanism thus prevents the operation of the firearm without its magazine. While rifles are not required to have a magazine disconnect mechanism, the state must concede that at least for semi-automatic handguns, the state deems not unsafe firearms for self-defense will not function without a magazine. Modern magazines, submits California, are more like founding-era cartridge boxes or ancillary equipment associated with soldiering that were not strictly necessary to fire a gun. Today, however, as pointed out above, some semi-automatic firearms will not function at all without a magazine, while others can fire no more than one round. As such, a magazine is an essential component without which a semi-automatic firearm is useless for self-defense. Therefore, a magazine falls within the meaning of arms. Judge Benitez continues. Now, Section B here of subsection B of Section 2, large capacity magazines are used for self-defense. So Judge Benitez writes, notwithstanding that the Second Amendment protects the right to keep and bear, the state's most troubling argument is that magazines holding more than 10 rounds are not being used for self-defense. By used, the state means actually fired. The state asserts there is no evidence that large capacity magazines are frequently used in self-defense. Continuing, the state asserts, to the contrary, the record reflects that it is exceedingly rare for an individual in a self-defense situation to fire more than 10 rounds. But without conceding the accuracy of the state's position, infrequent use or exceedingly rare is not the same as never. To support the state's argument, it relies on a statistician's conclusion that an average of only 2.2 rounds are fired in an average self-defense situation. Because more than 10 rounds in the average situation are not being fired for self-defense, magazines holding more than 10 rounds are not used or needed for self-defense. And because the Second Amendment protects, according to California, only those arms commonly used for self-defense, the state says larger capacity magazines are not commonly used and therefore are not protected arms. It is a remarkable reading of Heller, McDonald, Caetano, and Bruin to say that if a gun is not fired more than 10 times in self-defense, then the gun's larger magazine is not being used in self-defense. And if not used in self-defense, then not protected by the Second Amendment. Yet that is California's theme. In this court's view, it is a crabbed reading of the Supreme Court's Second Amendment decisions and not relevant to the text, history, and tradition test. The Supreme Court uses several descriptive phrases to describe the kind of firearms that are protected by the Constitution, but common to all is the notion that to be protected, an arm needs only be regarded as typically possessed or carried or commonly kept by citizens to be ready for use if needed. The Supreme Court has not said that the actual firing of a gun is any part of the test. Indeed, the Second Amendment does not say that the right of the people to keep only such firearms as they actually shoot shall not be infringed. McDonald begins 2 years ago in District of Columbia v. Heller. We held that the Second Amendment protects the right to keep and bear arms for the purpose of self-defense, and we struck down a District of Columbia law that banned the possession of handguns in the home. What mattered in that decision is the purpose for which handguns were possessed, not necessarily the actual use. California puts its weight on the words use, uses, and used. One problem with California's view is that it treats the Supreme Court's opinion language like the language of a statute. That is a mistake, because opinions, unlike statutes, are not usually written with the knowledge or expectation that each and every word may be the subject of searching analysis. We do not follow statutory canons of construction, interpretation, with their focus on textual precision when interpreting judicial opinions. Under California's reading, a homeowner who displays a handgun with a 17-round magazine to scare away home invaders has not used the 17-round magazine. Under the state's reading, even a citizen who fires his semi-automatic firearm 10 times or less to defend himself has not used his 17-round magazine in self-defense. Admittedly, one can find different meanings of the term use. For example, in the context of a criminal statute, the Supreme Court acknowledged use offers different possible meanings. The word use poses some interpretational difficulties because of the different meanings attributable to it. Consider the paradoxical statement, quote, I use a gun to protect my house, but I've never had to use it, close quote. Consequently, context is important, whether interpreting a statute or understanding a court opinion. So considering the words use or used in context, California's notion is far removed from the meaning indicated by the Supreme Court. Heller considered merely the possession of a usable handgun in the home. Focusing on the right to possess a usable arm, Heller said, we consider whether a District of Columbia prohibition on the possession of a usable handguns in the home violates the Second Amendment to the Constitution. Actual firing of a handgun in the district was irrelevant. Statistical surveys of shots fired in self-defense were not determinative. They were not even mentioned. Heller used a simpler test. Constitutional protection is afforded to weapons typically possessed by law-abiding citizens for lawful purposes, focusing on typicality and possession rather than frequency of firing. The Supreme Court McDonald decision says the right was also valued because the possession of firearms was thought to be essential for self-defense. McDonald's focus is on possession. And McDonald says the right applies to handguns because they are the most preferred firearm in the nation to keep and use for protection of one's home and family, focusing on a national subjective preference for handguns. There was no effort by the Supreme Court to condition the constitutional right upon some objective metric of actual handgun firing in self-defense. Bruin says the Second Amendment guaranteed to all Americans the right to bear commonly used arms in public. Bruin appears to focus on commonality. Bruin injects some ambiguity with the following phraseology, quote, the Second Amendment protects the possession and use of weapons that are in common use at the time, close quote. Bruin noted that in that case, no party disputed that handguns are weapons in common use today for self-defense, but did not say what it meant by use. So what does the Supreme Court mean by its phrase in common use? Is the focus placed on a weapon's commonality in society or the frequency of a weapon's firing? Bruin answers that question elsewhere in its opinion. Commonality is the focus. Consider the following sentence from Bruin, quote, drawing from the historical tradition, we explain that the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large. Close quote. Or consider this sentence from Bruin, quote, even assuming that pocket pistols were, as East Jersey in 1686 deemed them, unusual or unlawful, it appears they were commonly used at least by the founding, close quote. Bruin contrasts common pistols against unusual pistols. The focus remains on commonality, not the frequency of actual discharge in self-defense scenarios. Put simply, Second Amendment protection envelops weapons commonly or typically subjectively chosen by citizens to keep in case of confrontation. From Bruin, it is evident that the Supreme Court's focus is on whether a weapon is common or unusual among the citizenry. This, in turn, requires some sort of generalized numerical estimation of citizen ownership or gauge of present popularity. In Caetano, the concurring justices explained that the more relevant statistic is that hundreds of thousands of tasers and stun guns have been sold to private citizens who it appear may lawfully possess them in 45 states. That Miss Caetano did not actually energize and fire her stun gun made no difference to the Supreme Court. In her case, she did no more than display the weapon. She stood her ground and displayed the stun gun. Absent from the opinion, Caetano, is any discussion about the average number of times a stun gun is energized in an average self-defense scenario. Absent from the opinion is any objective metric counting the frequency with which stun guns have been fired. The measure of constitutional protection was that the stun gun was used in the sense that stun guns are widely owned to satisfy a subjective need for protection, and that the number in existence was in the hundreds of thousands. Applying the same measure to magazines, because it is the case that magazines holding more than 10 rounds are owned and possessed by millions of Americans to meet a subjective need for self-defense, this fact alone entitles such magazines to Second Amendment protection. When a magazine is commonly owned by Americans with the subjective intention of using it for self-defense, it is enough to say that it is in common use or typically used for self-defense, as the Supreme Court employs the phrase in its opinions. Probably the vast majority of Americans that own magazines of 11 rounds or more keep them and use them for self-defense in the same way that a driver puts on and uses a seatbelt in the case of a collision. Though collisions rarely happen, the seatbelt is used for protection and to be ready for the unexpected collision. A reserve canopy is used on a parachute jump, although it is not deployed, in case the main parachute fails. A cell phone in one's pocket is being used when waiting for a telephone call or in the event one needs to make a call. In the same way, a firearm kept on one's nightstand is used for self-defense even when the night is quiet. It is kept and used in case of confrontation. A person may happily live a lifetime without needing to fire the gun in self-defense. But that is not to say that such a person does not use their gun for self-defense when he or she keeps it under the bed with a hope and prayer that it never has to be fired. In 2016, an 81-year-old Uniontown, Pennsylvania man and his elderly sister were at home when at night an intruder broke in. In the ensuing struggle, the older man fired one shot from his gun at his attacker. The victim said he had never before fired his gun and that it had been sitting on his nightstand for 30 years. California would say that the victim did not use his gun for self-defense on any day of those preceding 30 years. And if his gun had a magazine with 11 or more rounds, California would argue that the victim never did use his large capacity magazine in self-defense. This court would say that the victim used his gun every night of the 30 years he subjectively kept it on his bedroom nightstand in case of confrontation, including the night of the burglary. And if his gun had been equipped with a large capacity magazine, it could correctly be said that he also used the large capacity magazine for self-defense every night of the 30 years he subjectively kept it on his bedroom nightstand in case of confrontation. Man, this guy's good, Judge Benitez. All right, next section, section C now, titled The Invention of the 2.2 Shot Average. Without agreeing that when the Supreme Court discusses firearms in common use, it means commonly fired, even if it did, the state's, California's, statistic is suspect. This is California's claim that on average, a defender only needs 2.2 shots in self-defense. California relies entirely on the opinion of its statistician for the hypothesis that defenders fire an average of only 2.2 shots in cases of confrontation. Where does the 2.2 shots originate? There's no national or state government data report on shots fired in self-defense events. There's no public government database. One would expect to see investigatory police reports as the most likely source to accurately capture data on shots fired or number of shell casings found, although not every use of a gun in self-defense is reported to the police. As between the two sides, while in the better position to collect and produce such reports, California's Attorney General has not provided a single police report to this court or to its own expert. Without investigatory reports, California's expert turns to anecdotal statements, often from bystanders, reported in news media, and selectively studied. She indicates she conducted 2 studies. Let's see. So I want to go back to where it says the Attorney General of California has not provided a single police report to the court or its own expert. That's footnote 98. So Judge Benitez in footnote 98 shares an exchange that occurred between the court and this expert statistician. Allen, the expert, the statistician, asked the state for police reports, but she did not receive them. The court, quote, "Let me ask you a question. Did you ever ask, for example, the Attorney General of California if he would get you the law enforcement reports of home defense shootings that may have occurred where the homeowner or the person at the home fired shots at someone who was intruding?" Statistician. Yes. So I did ask both from the state of California as well as from a number of other states that I've worked for. I've asked for data on incidents of exactly that, or whether there was a broader set of data that they had that I could then review. The court. And did you get that from the state of California? Statistician. I did not. It was my understanding that the state of California did not have that data or did not have that in a way that it could be reviewed. That type of data is not collected. That's footnote 98. So without investigatory reports, the state's expert turns to anecdotal statements based on these 2 studies of newspaper stories. We all know what they're worth. She opines that it is statistically rare for a person to fire more than 10 rounds in self-defense and that only 2.2 shots are fired on average. Unfortunately, her opinion lacks classic indicia of reliability, and her 2 studies cannot be reproduced and are not peer-reviewed. Reliability and validity of 2 aspects of accuracy and measurement. Reliability and validity are 2 aspects of accuracy in measurement. In statistics, reliability refers to the reproducibility of results. Her studies cannot be tested because she has not disclosed her data. Her studies have not been replicated. In fact, the formula used to select 200 news stories for the Factiva study is incomprehensible. For one study, the statistician says she conducted a search of stories published in the NRA Institute for Legislative Action magazine, known as the Armed Citizen Database, between 2011 and 2017. There's no explanation for the choice to use 2011 for the beginning. After all, the collection of news stories goes back to 1958. Elsewhere in her declaration, she studies mass shooting events, but for that chooses a much longer time period, reaching back to 1982. Likewise, there's no explanation for not updating the study after 2017. However it is that they were chosen, some 736 incidents in the Armed Citizen Database were said to be analyzed, and the number of shots tabulated. But details are completely absent. The statistician does not list the 736 stories, nor does she reveal how she assigned the number of shots fired in self-defense when the news accounts use phrases like, the intruder was shot, but no number of shots was reported, or there was an exchange of gunfire, or multiple rounds were fired. She includes in her 2.2 average of defensive shots fired incidents where no shots were fired. One would expect the impact of the statistician's choice to include a 0 for a no-shot event to be significant, because even using her number, 32% of the events in the home in California were no-shot events. She also reported no incidents in California where more than 10 shots were fired in self-defense among the stories she reviewed. It seems obvious that in a state where magazines holding more than 10 rounds have been illegal to buy or sell for 20 years, law-abiding citizens are using the smaller magazines that the law requires for self-defense. Absent from the expert opinion is a statistic reporting the average number of shots fired by criminals. Also absent is the number of intruders, or whether the homeowner was able to escape unharmed. In another example, it's not evident from the study how she counted the number of shots fired for one story in the collection where a homeowner fired back and 3 intruders suffered 8 gunshot wounds. Considering most victims missed some of their shots, one would expect in defending against 3 attackers that more than 8 shots were fired in self-defense. Instead, all that the court, Judge Benitez, is told is, when the exact number of shots fired was not specified, we used the average for the most relevant incidents with a known number of shots fired. For example, if the story stated that shots were fired, this would indicate that at least 2 shots were fired, and thus we used the average number of shots fired in all incidents in which 2 or more shots were fired, and the number of shots specified. The statistician does not reveal the imputed number substitute value that she used where the exact number fired were not specified, so her result cannot be reproduced. Interestingly, substituting an imputed average for all the times the number of shots fired is unknown tends to bring the overall average of shots fired down towards 2.2. For example, if there are 10 incidents of self-defense where 9 times the victim fired 2 shots, and 1 time the victim fired 13 shots, the average number of shots fired would be 3.1, but the percentage of times more than 10 shots were needed for self-defense would be 10%. For a second study, the statistician says she conducted a word search of a news aggregator called Factiva. Factiva is a commercial database behind a paywall to which the court and the public have no access. Even if one did have access to the Factiva database, one could not repeat her study. The statistician's methodology for the Factiva study is incomprehensible. For the Factiva database of 70 million news stories, her word search returned 35,000 stories. From there, she somehow selected 200 stories of defensive gun use in the home and set out to analyze the events. As with the Armed Citizen study, the statistician does not provide a list of the 200 studies she analyzed. Compare that to the long, detailed list of 179 mass shooting stories she included in the second part of her declaration. For the Factiva study, there's no way to check her analysis or her math. And once again, she includes in the averages those events where no shots were fired, bringing the overall average down. Had a table of the stories she and her team analyzed been supplied, it would certainly reveal important information. For example, this court randomly selected 2 pages from Allen's mass shooting table, pages 10 and 14. From looking at these 2 pages, assuming that the sources for the reports were accurate and unbiased, the court is able to make statistical observations, including the observation that the number of shots fired were unknown 69% of the time. Without a similar table for the NRA or Factiva studies, this court cannot ascertain the number of shots fired in each incident, the number of times a homeowner possessed a large capacity magazine, the number of times the number of shots fired were unknown, whether the homeowner was unharmed, or the number of intruders. The statistician's 2.2 shot average is suspect for larger reasons. The whole statistical exercise is based on hearsay, anecdotes, hearsay upon hearsay news reporting, rather than police investigatory reports. A database of news articles lacks the usual indicia of accuracy and reliability of admissible evidence. According to 15 national polls conducted by non-law enforcement agencies, there may be from 760,000 defensive handgun uses to 3.6 million defensive uses each year. Compared to the comprehensive details given for her study on mass shooting events, the NRA and Factiva studies are curiously lacking in depth and breadth and causes the court to deeply discount the statistician's opinion. This court, Judge Benitez, is aware of its obligation to act as a gatekeeper to keep out junk science where it does not meet the reliability standard of Daubert and Federal Rules of Evidence 702. In a bench trial, the relevancy bar is low, and Rule 702 is to be applied with a liberal thrust, favoring admission of evidence. While opinions and evidence may have been deemed admissible in some cases, the evidence has been given very little weight or no weight at all. This is a fact finder's role. Challenges that go to the weight of the evidence are within the province of a fact finder. So while the questionable expert testimony was admitted, it has now been weighed in light of all the evidence. In assessing expert witness opinion, a court looks to see whether the opinion given is newly made or whether it grew naturally out of research conducted outside of the litigation. Bias may be evident, according to legal authorities, where the expert forms an opinion without peer-reviewed scientific support or before examining sufficient data. Bias may also be evident where an expert opinion is formed solely for the purposes of litigation. Here, the court is mindful that for scientific evidence to be admissible, the proponent must show that the assertion is derived by a scientific method. An opinion based on unsubstantiated and undocumented information is the antithesis of scientifically reliable expert opinion. The court must assess the expert's reasoning or methodology, using as appropriate criteria as such as testability, publication in peer-reviewed literature, known or potential error rates, and general acceptance. Methods and procedures must be followed. An undisciplined speculation is not science. To aid courts in exercising this gatekeeping role, the Supreme Court has suggested a non-exclusive and flexible list of factors that a court may consider when determining the reliability of expert testimony, including 1, whether a theory or technique can be tested. 2, whether it has been subjected to peer review and publications. 3, the known or potential error rate of the theory or technique. And 4, whether the theory or technique enjoys general acceptance within the relevant scientific community. The statistician's study for California relies on unverified, uncorroborated, second or third-hand anecdotal information. Normally, a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Assuming its relevance in the first instance for Bruin purposes, this statistical analysis has minimal indicia of accuracy or reliability. In the end, Allen opines that an average of 2.2 shots are fired in self-defense gun scenarios, and only 0.3 of such incidents involve more than 10 shots fired. Yet even 0.3% is a lot in terms of actual times a citizen needs to fire his gun in self-defense. Using the estimate from the Centers for Disease Control mentioned earlier of 500,000 to 3 million times per year nationally, and extrapolating the 0.3% where more than 10 shots were fired, per the statistician's report, would mean defensive gun uses of more than 10 shots happen between 1,500 and 9,000 times every year. All right, folks, that puts us about halfway through this opinion, and we're an hour in. I'm not going to talk for another hour. I will, however, I'm enjoying this so much, I will do another show tomorrow where we complete the reading of this decision. Stopping here, we'll continue tomorrow from Section D. Magazines holding more than 10 rounds are not dangerous and unusual. will continue tomorrow at noon Eastern time. So look out for that email from me letting you know how to access that show. The reading of Duncan versus Bonta by Judge Roger Benitez. Great work, Judge. Having a great time reading this one. All right, folks. Pausing the reading of Duncan v. Bonta for today. I want to remind all of you about our upcoming Law of Self-Defense live online class, our advanced class, our full-day course of instruction. We only teach this one twice a year. It's coming up a week from this Saturday, October 7th, from 9 a.m. to 4 p.m. Mountain Time. It's our most comprehensive course of instruction for lay people. This is the same content we use to teach continuing legal education to lawyers, but translated into plain English. All those red bullet points, those are the more than 100 distinct use of force issues that we explain in plain English to all of you in this course. If you can't make the date for the live stream of this course on Saturday, October 7th, register anyway. We'll make the replay of it available to all the registered students, those who could attend and those who couldn't attend. And you can watch the class over the next couple of weeks in pre-recorded format. Again, there at the bottom of the screen, you can see the URL for that, lawofselfdefense.com/advanced. The next one of these is not until spring of 2024, folks. So I urge you to take advantage of this opportunity today. All right, with that out of the way, I'll just remind all of you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Oh, wait a minute. I almost forgot the chat. Sorry, chat. I've just been doing a lot of reading, so before I do the final closeout and end the show, let me see if there are issues I need to address. We were, in fact, I should take a look at the super chats too, shouldn't I? Just to be comprehensive. We do super chats if they're more than $10 or more, folks, for super chats. I forgot to mention that at the start. Yeah, no super chat. So let me take a look at the member chat here. Sorry, folks. Okay. Brian says, predicting the California roster and modern sporting rifle ban will fall by the time we're carving turkeys in our dining room this year. That would be nice. So California is one of those states. Massachusetts had the same thing when I lived there. An improved gun list. So you were only able to purchase guns that were on this approved list by the state. And many common guns were not on the list. Very arbitrary list. And by modern sporting rifles, Brian means AR pattern rifles. Perhaps the most common rifles owned in America by many millions. Let's see. Tony asked, does this now have precedential value? It wouldn't, because it's a trial court decision. But the reasoning applied by the trial court and how aggressively he cites back to Heller, McDonald, and Bruin means that any other rational federal court is going to have to arrive at the same conclusion. They could go irrational. If they go irrational, then it would have to be appealed. But the holdings of McDonald, Heller, McDonald, and Bruin make this conclusion unavoidable if legal reasoning is being applied. Let's see. There is a Wendy included a link here to Michael and Associates. Oh, it's the decision. Yeah, I'm going to put it in the. Thanks for that, Wendy. That's fine, of course. I also have a link to decision in the blog post version of today's show, so it's there as well. And I think that's it. All right, folks, thank you for not too many. I guess it's not that easy to have questions when I'm just reading a court decision, really. But again, if you carry a gun so you're hard to kill, if you carry pepper spray so you're hard to kill, if you practice jujitsu because you're hard to kill, I do all those things. So I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.